Thank you for this day. Thank you for this vision that you have allowed us to have. Thank you for our board. Thank you for our office workers that are not expecting. But most of all, thank you for our guests that are here today with us. Amen.
Jennifer Reed. Nicole Godin.
Present.
Renee Bosworth.
Present.
Sean Petrie.
Present.
Raymond Cozy.
Present.
Lauren Queen.
Present.
Kate Holmes.
Present.
7 board members present, and there is a quorum.
Thank you. Okay, at this moment, we will allow for public comments. Ms. Renee, you want to go over?
Hi, good morning. All right, so first day you send the new comment cards. I know it's kind of small, we already had them printed, so they'll be a little bigger and a little more clear to read. So if you would like to speak, please fill out the card and give it to Ms. Tasha, and she'll get it up to us. Thank you.
Quick question. If something comes up and you've not filled out a card as a response to something that someone says, how are you handling that?
I would prefer the card to be filled out, just to keep it, all in the same flow.
The comment board is for item agenda.
Yeah, if it's something coming from the agenda, and can you respond to it or ask a question to someone that speaks on something on the agenda, or you have to wait till later?
There'll be a time for public comment under that agenda item, so if you have the card filled out, just hand it to her and she can come bring it up.
Okay.
Any other question? You can ask a question.
Okay, so we're going to move on to the acceptance of the agenda, but before we do that, I have 2 amendments that I would like to ask the board to approve for. One is just to simply remove the hearings. We had to postpone that. And underneath the order of new business, I would like to add to on item B, just the beginning discussion for possible legislation form bill. And we'll change line item B to C and line item C to D.
I make a motion to accept the revised agenda.
I second it.
All in favor? Aye. Any opposed? Okay. The next line item is the disposition of December 1st, 2025 board meeting minutes. And although this is just our second meeting here, we actually do not have them with us, but they were sent via email to all of us. Everyone has reviewed their email for the disposition of minutes.
I make a motion to accept the December board meeting minutes as were emailed to us. I second.
All in favor? Any opposed? Okay, so moving right along, we'll go on to the consent agreements, Ms. Kelsey.
Yes, good morning. We have 2 consent agreements this morning. The first one is for Ms. Jody Cossack. This is a data violation of December 6, 2024 for operating an unregistered salon. She agreed to a consent agreement where she pay a fine of $200 plus cost of $450 for a total of $650 plus a 1-year probation. She has signed a consent agreement and paid the fine. And the second one is for Ms. Mackenzie Marshall. This is a violation from April 4th, 2025, also for operating an unregistered salon. She agreed to a consent agreement where she paid a fine of $200 plus cost of $450 for a total of $650, and she agreed to a 1-year probation. And she also has signed a consent and paid the fine. So I would request approval of these 2 consent agreements.
Thank you, Kelsey.
I make a motion to approve the consent agreements as Kelsey has presented today.
I second it.
executive order.
I have copies. Okay. I made copies of one of the petitions for declaratory order. We have 5 that are identical, just because we've had some changes on the board and this has been pending for a long time. So I'm just gonna pass them down and let everybody take one, just for your reference, because you may not have it with you. As you're aware, we received 5 petitions for declaratory orders, and they all ask for the same question. So we discussed at the last meeting, draft. We had waited a long time for an Attorney General's opinion, and then go ahead and sending a draft for review by the Occupational Licensing Review Division. So I did prepare a draft. I did also receive a response to the Attorney General's opinion request, and I'm just going to read it. It's a letter dated December 12, 2025. It says, "This office acknowledges receipt of your opinion request and your correspondence. You present the following questions." These are the questions that the board asked of the Attorney General. Whether Louisiana Revised Statute 49-968D requires the Cosmetology Board to issue a declaratory order on matters not related to the scope of practice. 2, whether the Cosmetology Board's authority pursuant to LARS 49-977.4 includes authority to issue a declaratory order interpreting the Louisiana Administrative Procedures Act. Number 3, whether the Cosmetology Board's authority pursuant to Louisiana Revised Statute 49-977.4 includes authority to issue a declaratory order on the constitutionality of provisions of state law, significantly the Louisiana Administrative Procedures Act, Louisiana Cosmetology Act, Louisiana Revised Statute 37-561 and following, in light of Louisiana Constitutional Article 5, Section 16, which vests the state district courts with original jurisdiction over civil matters. 4, whether the 7th Amendment to the United States Constitution applies to administrative hearings by a licensing board pursuant to the Louisiana Administrative Procedures Act. This is the response. Please be advised that pursuant to the longstanding policy of the office, we are unable to issue an opinion on matters that are currently in litigation or subject to imminent litigation. Should you have further questions, please contact me. So the response is that the Attorney General will not be issuing an opinion because it appeared imminent that there would be litigation. So I went ahead and drafted, per your instructions, a proposed declaratory order after doing some additional research. And the particular question that the board has been asked to answer is whether individuals or entities charged with the violation of the Louisiana Cosmetology Act, the rules promulgated pursuant to the Louisiana Cosmetology Act, or other applicable provisions of Louisiana law which could result in the imposition of a fine, have a right to trial by jury as provided by the 7th Amendment to the United States Constitution. The 7th Amendment to the United States Constitution provides in suits at common law where the value in controversy shall exceed $20, the right to trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in a court of the United States other than rules of common law. So in order to determine, this is my recommendation, and so the board is free to alter, amend, or whatever you feel is appropriate. But the declaratory order just kind of states the questions that were being asked of the Attorney General. It states that the Attorney General has issued a letter declining to answer the questions. So the proposed findings of fact are that the purpose of the Cosmetology Act is to promote, preserve, and protect the public health, safety, and welfare by and through the effective control and regulation of the practice of cosmetology.
The legislature declared the license of all persons who perform cosmetology, the licensure of all facilities where cosmetology is taught within the state, the licensure of all facilities where cosmetology services are offered within the state, and the licensure of all persons who supervise individuals performing cosmetology within the state are declared necessary to ensure that only qualified persons be permitted to engage in the practice of cosmetology at facilities meeting appropriate standards. That's Louisiana Revised Statute 37562C. The Louisiana Cosmetology Board was created by the legislature in Louisiana Revised Statute 37571. Louisiana Revised Statute 37575 requires the Cosmetology Board to establish and enforce compliance with professional standards and rules of conduct for cosmetology. With certain exceptions, the Cosmetology Board exercises its duties, powers, and authority in accordance with the Louisiana Administrative Procedures Act as required by Louisiana Revised Statute 37575A11. Louisiana Revised Statute 581A prohibits engaging in the practice of cosmetology without a current certificate of registration for the appropriate area of practice. Louisiana Revised Statute 37600 provides grounds for suspension, summary suspension, and revocation of certificates of registration. Louisiana Revised Statute 37601 authorizes the board's inspectors to issue a citation and collect a fine of $25 per violation up to a maximum of $300 per week from any person, school, or facility, provided that the registrant waives his rights to a hearing. So that's significant because the consent orders, as you just approved, those individuals waive their right to any type of hearing, whether it's by a jury, by the board, by a court of law. Louisiana Revised Statute 37602 requires a hearing upon the filing of a written complaint with the board charging any registrant with a violation of the Cosmetology Act. Upon proof of a violation of the Cosmetology Act, Louisiana Revised Statute 37604 authorizes the Cosmetology Board to order the payment of up to $200 per violation not to exceed a total of $5,000. The Louisiana Administrative Procedures Act, which is found in Louisiana Revised Statute 49950 through 980.1, requires agencies to provide by rule for the filing and prompt disposition of petitions for declaratory orders and rulings as to the applicability of any statutory provision or rule or order of the agency. Louisiana Revised Statute 49968D authorizes declaratory actions for declaratory judgments upon showing that review of the validity and applicability of an agency rule in a contested adjudicated case would not provide an adequate remedy and would inflict irreparable injury. So the conclusions from all of those facts proposed are that the requests for declaratory orders presented to the board do not seek an interpretation of the Louisiana Cosmetology Act or any rule or order of the agency, and therefore the Cosmetology Board is without authority to interpret the applicability of the 7th Amendment to the United States Constitution to Louisiana law. The cases that were relied upon by the petitioners in supporting that application were two main cases, the SEC versus Cherkesky, which is a United States Supreme Court from 2024, and United States versus ERR LLC, which is a Fifth Circuit case, United States Court of Appeals for the Fifth Circuit, which has jurisdiction over matters in the state of Louisiana. The cases relied upon by petitioners after review hold that the 7th Amendment of the United States Constitution guarantees a jury trial in a court of the United States for common law claims brought by the United States. There's no provision in Louisiana law requiring a trial by jury for violations of the Cosmetology Act or rules brought by the Cosmetology Board pursuant to the Administrative Procedures Act. The proposed order would read, it is hereby ordered, adjudged, and decreed that individuals and entities charged with a violation of the Cosmetology Act or the rules promulgated thereunder or applicable provisions of Louisiana law would which could result in the imposition of a fine, have no right to a trial by jury. And it is ordered a judge to decree that the foregoing order shall not be effective until submitted to the Occupational Licensing Review Program of the Louisiana Attorney General's Office for review. Anyone have any questions, comments, suggestions, or revisions?
Yeah, so basically, the lawsuit was saying that
This is not about a lawsuit, this is about the petition that was
Right.
handed out.
a petition, okay. So what they wanted is a jury trial with anything over $20.
They want an order stating that a person who is subject to a fine over $20 would have a right to a trial by jury.
Right, and the last statement that you made says that they've already ruled on that, and
The last statement that I made would be what you would rule. That's my recommendation of a ruling, but that could be altered, amended, revised.
right, so I mean, if this goes through, that means any violation for any fine in the state of Louisiana over $20, that person would have a right to a jury trial, is that correct?
So my interpretation of the cases relied upon is that they're not applicable to this board.
Okay.
And I don't think that really this board can opine beyond what the law is applicable to other boards or other agencies or whatever. But the cases that they're relying upon do not, in my opinion, this is just my legal opinion, based upon research though, that those cases apply to actions brought by the United States, an agency of the United States, and under common law. And that's not really what is being done here. The actions that you have are based upon rules and laws that are requirements to hold a license. So they're administrative hearings before an agency that holds your license.
Right. So from a high level, your interpretation is saying that any fine over $20 from the cosmetology board, they do not have a right to a jury trial.
That is my opinion,
Okay.
and that's my recommendation. If you all want additional research, if you want to revise it, if you want somebody else to look at it, we've tried to get the Attorney General to look at it, and they
Right.
declined to do so.
Okay, great.
And I just want to say, we do have a representative of the Pelican Institute here, Ms. Hardison, who submitted the request. Generally, and this is kind of new, I think for a lot of you, because we haven't had a petition for declaratory order in a long time, really. But the process is generally there's an evidentiary hearing, but I reached out to the attorneys for the Pelican Institute and asked them, you know, how long it was going to take to put on their case. And this was months back, and they said that it was not necessary to have an evidentiary hearing, that all of the materials that were relevant were presented, were attached to their request or included in their request. So this is being conducted a little bit differently than we ordinarily conduct a petition for declaratory order. And if that's not accurate, Ms. Hardison can adjust.
Are there any other questions or comments? What's our next step?
So, you know, the rule does require for an expeditious resolution of a petition for declaratory order. This one, you know, there was an attempt to get advice from the Attorney General, so it's been delayed. It doesn't meet the time requirements. So my suggestion is that the board take some action, either adopting the proposed declaratory order, and we would then submit it to the Attorney General's office for review to determine whether it's an order that needs review of that agency. Our contract with that agency is somewhat new, and we are a little bit unclear as to exactly the scope of the orders that have to be reviewed, but out of an abundance of caution, we would submit it. They can always say it's not within the scope if it's not. But I think that the board needs to take some action either today or as soon as possible because of the deadline.
Does everyone feel comfortable making a decision today on moving forward? No.
possible to make that decision, or is that too late? Do you think?
We're way past the deadline. So, I can, if you all want some additional time to submit it, I can submit it to the OLRP so they can be looking at it at the same time.
So what you're asking now is just what is our response to the declaratory order?
Correct.
And your recommendation for our response is that we do not have the authority to make that sort of decision.
The suggested response is that we're determining that the right to jury trial does not apply to actions by the cosmetologist. Correct. So a declaratory order, once you all rule upon it, just like in an administrative hearing where you would impose a penalty, is subject to review by the courts. And in our case, it's subject to review by the 19th Judicial District Court. So if the requesters don't agree with the opinion, they have the right to seek court review.
Since it's taken so long as we stand, I would like to make a motion that we move forward with what Sherry has suggested our response be, and move forward with that today.
I'm in agreement with that.
Yeah, I mean, I'd like to see a copy of your opinion and read it before I would make a decision.
Would it be possible to then go into like executive session to be able to discuss and like read this before we make a vote? Or no, or just give us a few minutes, even if it's not in a private session, to read and then come back and vote?
We don't have it on the agenda. Notice for executive session is not, even though the Attorney General says is the subject, it could be the subject of eminent litigation. Of course, all declaratory orders can be appealed, so they can wind up in the courts. I don't believe that we have the authority to go into executive session at this point. We may at a future date.
What if we give you an opinion at the end of this week? Would that be too late?
It has to be voted on in an open session, so that would be today. You could certainly have a special meeting, or you could submit it to the Attorney General's office, and then finalize it at the next meeting.
Or we can take a few minutes right now and I would be more comfortable if everybody took a look at it.
Yeah, are you going to be sending, which you're not going to be submitting it today, you would send it to the Attorney General's office and then to review, and then, why don't we just send it to the Attorney General's office, let them review it, and if they make any edits, then we can review it again, because if they make edits, I would like to review it again. So I would.
The proposed order does say that it's not effective until it's reviewed. So it would be adopted, but it wouldn't be effective until it's reviewed.
Right, so, I mean, you could read it now, but the Attorney General's office does make amendments to it, we have to read it again. So, for the understanding of this, I agree with what you said, and if I take 2 minutes to read this, then send it to the Attorney, send it to their Attorney General and get their opinion. I feel comfortable doing that now, and because they didn't make edits, they have to review it again and make a decision.
I don't know how long it'll take to get it back. So our next board meeting is, 4 weeks from now. So I don't know that I'll get it back that fast.
Okay, so they're just asking that we agree to this, to sit there, and then we'll have a chance again to say, yes, I agree with the Attorney General's opinion or not. Or edits or whatnot.
So by putting the language in several, and Kelsey might have some comments on this as well, because the review process is a process that's been added on to our disciplinary orders, even summary suspensions do have to go there. It kind of delays the process because it depends upon the volume of things that office has and receives. So we have started putting in our orders that it's not effective until it is reviewed, because we don't know if it's 1 month or 2 months or 3 months. It depends upon the volume that office is handling. So a lot of boards send in a whole stack of orders. It's going to take longer if they're kind of caught up. Then they're going to turn around faster. And some things take more research than others. I have not, and I have consulted with others, about whether a declaratory order has to go for review. And nobody really knows the answer for that. So we're still in those initial stages that until we send something in, we don't really know whether this category of orders goes. But then once they said, if they were to say, oh, we don't have to review this, then we would know in the future. But no, I couldn't find anybody that had submitted or even had a declaratory order. There's very few of them actually. If y'all want to take our recess break and come back to it at the end of the agenda.
I make a motion for a 15-minute recess, just so we can all have a chance to read over this real quick.
Second.
All in favor? Any opposed?
I'll set a timer.
And Ms. Kate has recused herself and left the room. So, after reading over it, let me first, Robert Burns, you want to take that comment? You can comment on the order?
Yes, ma'am.
Okay.
And we do have the podium and the mic.
That's what I'm going, oh, shoot. If I don't lose my camera beforehand, because I've always been accused of, hey, you're always behind the camera, so. The problem is I have no idea if it's in it properly or not. I'm supposed to set the votes over here. All right, well, first, thank you for the opportunity to address you on this. As I'm sure you are aware, I have posted numerous blog posts with regard to this matter. I'm just going to be very blunt, which I have said on the blog and will state here as well. I think it was inappropriate to seek an Attorney General's opinion on this for the obvious reason that she was going to be conflicted because of the potential for imminent litigation. I stress that over and over and over and over again. And I do think it's a sad commentary when it takes the filing of a writ of mandamus to get the board to do what it should have done in September of 2024. So this has been a literal year and a half stalling of this matter, when to me, it should have been common sense that Lsbc was not going to issue an opinion on this. Obviously, once the frustration level got so high that the filing of a writ of mandamus became necessary because nothing was being done, all of a sudden there's quite a bit of action. Now, obviously, the writ of mandamus can now be dismissed as being moot, because you're obviously going to do what you should have done way back in September of 2024. So I think there was an enormous amount of angst, I'm sure considerable frustration on the level of the plaintiffs, and I don't think any of it was necessary. But at least now, January 2026, we are finally where we should have been in September of 2024, when the request for this declaratory order was first submitted to this board. So I guess for those who would have an appreciation for denying delay, well, strike deny because it was never denied, but certainly delay. I think 16 months is a long time, and it was on the agenda every single time. So it's kind of incredible that everybody's being, well, we got to hurry, let's take a recess. I understand that, it's prudent. But this matter should have been addressed a long time ago. And I think that each one of you has enough common sense to know what's coming down the pike after the order, irrespective of what it may say, is going to transpire. So With that, that's my public comment on this particular agenda item. I do have one other, but I'm sure at that point we'll be afforded that opportunity. Thank you so much. Oh, and this is nice because there's no way that that microphone isn't picking this up, so
Thank you, Mr. Burns.
you're quite welcome.
Are there any other comments, questions on this particular item? Can you hear me? I'm sorry. I was like looking. Are there any other comments on this particular item? Okay. So at this point, after everyone has read over Sherry's proposed response, are we ready to move forward? Or do we want to? Okay, so let's make a motion.
Do I need to remake my motion, or can my motion still stand from before the recess? Then I want to restate my motion for that. Sorry. I make a motion to move forward with the proposed response that Sherry presented.
And I second it.
All in favor? Any opposed? Okay. All right, we move on to line item 11, continuing education discussion / vote. Oh, I'm so sorry. Yes, we're getting Kate.
I just texted her. She told me to text her what happened. She was standing right outside the door.
Okay, so we'll move on to line item 10, continuing education discussion vote. The first line underneath that is discussion of waiting periods to enroll in instructor curriculum. Jean, do you want to elaborate on that a little bit? 11.
Just approval of the continuing education supervisor?
No. Line item, that's 11, and it's number 1, discussion of waiting period to enroll in instructor curriculum.
Oh, okay, yeah. So right now, there's a law that states that if you graduate cosmetology school or esthetician school, or school, any of the disciplines that fall under cosmetology, you have to wait an entire year to enroll in instructor program. Okay, so it doesn't say actively working; it just says holding a license. Okay, so I would like to remove that to where as soon as a cosmetology SD or nail tech graduates from school and gets their license, they can then enroll into a instructor program. Okay, but here's the thing, my thoughts were, I see people shaking their heads, like, I totally agree. I'm a school owner, and I want my instructors to have behind-the-chair experience to instruct. Totally agree with that. But we're falling into situations where we're it's hard to find instructors. So that's up to your school to hire an instructor that has no mind chair experience. I mean, that's your prerogative, you can do that. Also, I don't want to stop people from getting their instructor license. They can get it right away, then go behind the chair and work, but they just didn't want to, they wanted to continue with school because they're young, they already have an apartment, or you know, whatever it may be. Just continue your education, then go back, work behind the chair for a while, or whatever, and then they always have that to fall back on to be an instructor if they want to do that later. Because it's only, it's a 600-hour program, plus 500 by the state. But our school is a 600-hour program, so I would like to remove those handcuffs off of the students that possibly want to get an instructor license. And then, but people are gonna, the opposition is like, well, I wanted to have my insurance thing, but all you have to do is say, hey, we don't mind. If you're paying through school, if you want that to be required to then have a high chair experience, it's your prerogative to hire or not. But I think this is an easy handcuff to get off the students, and I think it would be good for us. So that's my opinion on that. And this is something that's going to be changed in legislature. So.
All right, Sean, thank you for that. I think part of what he's trying to say is, even though there's a 12-month experience wait period, there is no proof that they have any experience. It's just 12 months gone by. So as he stated, well, you can be actively engaged. You can get one job and then you've proven that you worked, and I mean, y'all know, I know what it says, but we really have no proof that they have been actively engaged. They go back after 12 months and re-enroll in school. It's a topic for discussion. I understand experience can be left up to the schools themselves. So it's just a topic for discussion for us to think about, or upcoming legislature to change that law. I'll move on. If there's any questions or comments about that particular line item from the board?
I agree with him on that issue, because once the student finishes the hours, why not keep them? Because they have theory knowledge. And this is what you want, more theory knowledge to education to the kids. Hands-on, they have it, but theory, they forget it. Coming out of school, staying in school, enhancing their skills, theory-wise. I agree with that.
And the national test that the students take is, I mean, I don't know the exact statistics, but probably feel that more than they would the practical portion of it. It's a lot of information, and coming right out of schools and passing that national test would probably, and they're, you know, easy to probably explain to our students as a teacher what's on that test, because they just came from taking that test.
All right, thank you, Sean. Thank you. Mr. Gozzi. I'm going to go ahead and move on to the second line item, and then I'll circle back for comments. Master Education License Renewal Period, John. I'll refer to Aaron for that response. Aaron, for the Master Instructor License Renewal Period.
Do you want a response as to why it is the way that it is currently? Okay. So currently, if you want to receive your master license, you have to submit your continuing education hours between January and March, which was not always the case. Before COVID, people were able to submit their continuing education hours at any point, and the system was able to track so that you would know if that person received their master license. Then, I think it was 3 or 4 years ago, I'm really not sure, don't quote me on that completely, but some time ago, they made it where if you're submitting your online continuing education, that you would do that between January and March, so it would be a 90-day period, because
Wait, not only submit it, but you had to take it. It was written that you had to take the online education between January and March and submit it in between January and March. And we went round and round, I know that for a fact, that's what it was. And that's what we need to change.
Right, so if somebody does continue education, then those hours are submitted. If they're done online, those are submitted between January and March, that 90-day period. And they would then, have their active instructor license. If it's submitted any time after that, it gets really difficult to track because the system is honestly so antiquated. The Windows server is a 2000 server, so it's 26 years old at this point. The submitting it throughout the year is not necessarily the challenge for a regular renewal, but it's a challenge for the master renewal. And so I kind of went back and, kind of being diplomatic, why can't we track this master thing at any other point in the year? Because it was done before, so why can't it be done now, And new into this role, I've only been in the office 14 days, technically. I learned that the reason why it happened was a few years ago when the staff members of the board had proposed it being done between January and March was because it kept crashing the system when they were going to try to update everything all the time for the instructor license renewals. And then you have to have the 5 years in a row of an active instructor's license to get a master instructor's license. So it was making it really difficult to track if you kept submitting all of this throughout the year instead of doing it in just a couple of shorter increments of time at the beginning of the year. This is my understanding of it. I had a very long discussion with our IT staff member about it, and that's what I was told. So if somebody has a license that has been expired, like an instructor's license that's been expired, anybody can go and take their continuing education and submit that to the board with their license renewal. It just won't come back as a master instructor license. Number one, because their license was expired, and number two, because it was submitted outside of that deadline. So it's not going to show up as that, but they would still have their instructor license. So that's the clarification that I have on that.
Yeah, but if anyone, okay, so you get your master's in instructor license, it's 5 years doing continuing education every year after year for 5 years. Okay, so you're saying right now, if they just don't submit it within those days, they don't get their master's instructor license. If that's the case, I completely disagree with that, because they've done it year after year to get their master's, because you're gonna have people 5 years ago that submitted it, that didn't think they were gonna be a master instructor, thought they were just gonna do this for 2 or 3 years, but they ended up loving it and doing it forever. Now they wanna get their master's instructor license. And the first couple of times they didn't submit it within those months. I think the only fair way would be, okay, look, if you want your master instructor license, on your 5th year, you submit it within January and March. But to get your continuing education, you should be able to do that any time of the year and submit it whenever. Oh, you can submit it and you keep it on your desk, and when they want to enter it, they can enter it between January and March. But some people, you got running businesses, you may forget. So I think we should do it anytime, submit it anytime, because you're submitting it via email or paper because our system is so old. Well, they don't have to enter it until when they want to enter it. The staff member, they can have a folder and we put it right here, okay, but in January 1st, they go and enter them all. But as far as submitting them, I think you should have to submit them anytime for either master or regular instructor. Now, keeping track of that, you can say, I would agree to master on their 5th year, they got to submit it within that time period, but you can submit it any time. It's just it's their decision when they're going to enter it into the system. And if you said it was crashing, if that's the excuse, crashing the system, well, they'll wait to the end of the deadline, March 31st or whatever, whenever they want to enter it, or whenever their internal deadline would be, because it worked for years and years. And so if that's the case, that's a simple solution. to fix scratch in the system. You do it once a year, they hear them all the time.
Yeah, I understand. I'm up for any solutions anybody has to this. I just know, like, again, I'm not an IT specialist. All I do understand technology. I don't understand a 2000 server and the technology that we're working with. So my understanding is that it's so delicate. I mean, we can't even turn the air conditioner to certain degrees in the building and makes the server crash.
Right.
So like, my understanding is we're kind of walking on this tightrope, and if somebody, like, you know, before this I did work in schools, I always submitted my continuing education with my renewal, which was in December, and I have always had a license. I've never had a master license, and I've done continuing education for 15 years. It doesn't matter to me, but I understand it matters to other people. So, I mean, for me, I hope the biggest fix would be the technology piece of this. Really looking at it, you know, that's to me like the biggest, that's a bigger concern than the master instructor thing, is getting the technology fixed so that things can function properly and easily.
Right, so are we voting on this today?
We can finish our discussion and decide. We are
Okay.
ready for a vote, but
I mean, I'm also coming from an education background. I am a licensed educator. I'm the director of 2 schools. So for, like Aaron mentioned personally, I renewed my license in June, which is my birthday. So I did not ever have a master's educator's license. I did continuing ed every other year as required. I have a staff now, and I know that it has been an adjustment moving to January to March. But I also know as a board member, when I heard from our office staff about our system, I think we made that decision in support of our office staff, trying to make it easier for them. So like, I understand both sides of it, and maybe, I don't know if like John is saying, if we can maybe, if they track it differently, I don't know. I don't know if that's something we can decide today, but
Right.
I understand maybe it needs to be January to March until we are blessed and able to receive the technology upgrades that we need. Maybe this can be just a short-term thing.
I'm gonna piggyback with that, I think the technology needs to be there, and it's a one push all at the same time. That's what I think. I think it's hard when there's different dates changing all the time throughout the year versus start of January 2027, we have a beautiful new server, a beautiful new site, and these are all the new things. I think it would be easier for all of the things to happen at once versus like people trying to keep track of it all.
Well, here's the issue. They've been doing it for how long? 30, 40 years. So that's
101.
100, okay. So for 101 years, they've been keeping track of it. They're telling me that they have a problem. I understand it, and I sympathize with the staff, okay? But we're board members representing the state. And this is putting a hinge and a handcuffs on, we have 28,000 cosmetology licensees, esthetician about this. I mean, we have 50, 60,000 people that are, we have 21,000 licensed cosmetologists, I think is what it is. But there are 30, 40,000 people in this state that now they have to take their oh no, we're talking of, this is for only instructors, right? Okay, well, we have 5,000 instructors, I think, in the state. So this is handcuffing 5,000 people, okay? And they have set a lot of people, including myself, that we had to take the continuing ed in January and March, January and March, and then had to turn it in within January and March. I know a lot of schools that had to retake it, and it cost them thousands of dollars when they changed this. And I think it's just really ridiculous that we have to do that. You should be able to take your continuing education. There's no other board, I don't think, in the state, and I did some research on this, that have a certain amount of months they have to take their continuing ed and turn it in this month. No, you take your continuing ed and you turn it in, and you should license. January and March, you got holidays. What if you get, they have people that had holidays and got sick and couldn't do it. And then they called the office and like, oh, we're making an amendment for you. You can't make an amendment for one person, not everybody. So my thing is, go back to where it all was, the way it's always been. And like I said, if it's a computer issue, we just hold on to them and do it 3 times a year. If you're having problems with a computer crashing, you know, you can do this when it comes here. So my opinion, go back to the way it was, take your continuing ed whenever you want to take it. Well, before your birthday, get your license due before your birthday, I mean. And like for our school, we have a teacher in service where they meet up one day after they've done it on a certain day in September, and then all of a sudden we're like, wait, we can't do it in September anymore, so we have to change our schedule, change the day off. I mean, it was a total disruption, and it's still continuing to be a disruption. They have many schools and instructors that I've talked to that had no license even in place, and they're still turning their continuing ed to get their license. So it's like, for some people that forget, oh, you're okay. No, this is not okay.
It's just for the master instructor. You can turn in your continuing education hours throughout the year. It's only for the master instructor.
Well, this must be new. This was
No,
not.
that was always the case.
No,
I just don't think it was clear maybe to everybody.
definitely wasn't. We've had many discussions with other school members, and it was, I got it in writing, crystal clear, saying, no, you have to have emails and letters sent to me saying, it has to be done and turned in into January or March. So if you're telling me now that we need a vote on it again, because it was voted previously being on the board, that you can take your continuing education any time of the year and turn it in any time of the year.
Or with your birthday renewal.
With your birthday, well, yeah, sure, with your birthday renewal. Yeah, I'm totally okay with that, but that's not the way it was stated or emailed to me or letter sent to me. So I'd like to re-vote on that, just so we have our record saying, we can take continuing ed any time of the year and turn it in any time of the year. And for master, sure, on your 50, it should be on your 5th year, turn in between those months, but this just changed. And so you have people that maybe want to get their master instructor license that took it, you know, any time of the year previously. And now, hey, on your 5th year, you turn in those months and write a letter explaining, you know, if you really want your master, hey, look, it's my 5th time, please look it up and get it. Give it to me. So I'd like to, you know, so it's on record, we can take our continuing ed any time of year, turn in and with your birthday and with your license. Can we agree to that?
Yeah, renewing your license on your birthday with your continuing education hours is already a thing. It was the master portion. It's hard for them to track that. And that's what I'm just speaking from what I've been told, and I guess we'll just see how it pans out. That's what we're gonna do.
So what I'm hearing is maybe we need to release clarification on what's now required and,
Yeah, because the letter was sent out to everybody stating exactly what I just said. It has to be done and turned in within this month. A letter was sent out to every instructor in the state. I have the letter and have emails clarifying.
That was for only online, just so everybody's aware. So
Right.
if somebody went
Correct.
to
It's only online.
the
Yeah,
Beauticians and Barbers
correct.
thing or any of that throughout the year, that can be submitted anytime. It was only for the online, and it was,
Correct.
like I said, 3 or 4 years ago that this was done. And it was because some people were sending
it was last
2
year.
certificates with their license renewal, and that would only equate to 4 hours, and then they would go and do 2 more online things in June, and they would send 2 more, and they were expecting the staff members to continuously keep track of, this person has 8, this person has 10, this person it just got really weird for them. That's my understanding too. So instead of them sending all 16 hours worth of certificates at one time, there was a little bit of a rainfall kind of happening. Like they were sending them in as they were doing them throughout the year instead of with the renewal and the full 16.
Well, that's real simple. So
I know.
fix. All you do is say, hey, no, you send them all at once. If you
Right.
send in 4 hours, we're going to go in the trash. No, you send them all at one time. They don't go away. All you do is print out the
I mean, I know that.
certificate.
because
Yeah,
that's
so
what
we
I
just
did.
explain that to somebody.
Yeah.
So right now, you're able to do, say if you go to Lsbc, that is mailed in with your birthday renewal. But what if you're a master instructor and you're trying to go for that?
Online or
You have to do online.
You have to do online
Or
for master
Or
instructor. I
something.
think that may be part of the, because I
Or
wasn't
in
sure of
person,
that
right?
either.
Yeah.
It can be any continuing education between January and March for the master instructor license. That way it can be tracked. The other portion, as long as they're sitting in all 16 at once, that's where I think there was confusion too. And I think I was actually at that board meeting a long time ago, and I remember the discussion about it, because it was coming in like a trickle, and I had forgotten that, much like I didn't understand why they couldn't just go back and start doing the master all throughout the year, and so I kind of questioned the staff about that. And so when they explained to me that the last time they tried to do it all throughout the year, it was shutting down the server for 2 or 3 days at a time. So something kept happening when it's loading, the system is antiquated, so.
They don't have to do it within this month, it's just to turn it in.
Correct.
Right. For all master only,
Correct.
master only, okay.
Yes.
Well, we need to write this, clarify this again, and send
Exactly.
emails out to everyone, because the email, I got about 10, when I was on the board, I got 10 phone calls from other schools freaking out. Including myself, it cost them thousands of dollars, and it cost me a lot of money as well, because I had to go back and had to pay for these courses again, because we had just in September. So when we make rules like this, we really need to clarify it a little better, and I think you're doing a great job, appreciate it.
Okay, thank you, John. I'm trying, okay? Going at it diplomatically, like I said, I want to know why they were resistant to not doing it throughout the year, because I understand what y'all are saying, you know, so yeah. But then once you understand the reasoning behind it, it does make sense, and hopefully that can be resolved too this year.
And we need to make this clear soon, because it's beginning of January, so these instructors aren't like scrambling
Yeah,
to try to take a continuing ed this
Absolutely.
month. So let's send one last email out
Yes.
to everybody saying, look, we know we revised the.
we'll send them a letter,
continuing
yes.
ed, yeah. You
Or-
can do it anytime, turn it in anytime.
But if
Once
you
you're
want
master
masters
instructor,
through
you
that
got,
period of time.
you got to turn it in within 3 months.
Correct.
You don't have to do it.
Yes. And I'm trying to get you more continuing education options, which I will get to that in my report, Sean, okay?
Okay.
Okay, so from all of that, it's my understanding that we are going to go back and make it, we're going to clarify that it is master, educator, instructor license only that has to be turned in within the months of January and March. Okay, we're all clear on that. So the office will make clarifications, send out letters.
One more thing. So to keep your license, you turn it in with your birthday,
Yes.
and then you turn it in again.
It's every other year.
Yeah, well, with your
Yes.
master's, you have to turn it in every year.
Correct, but you just,
Right,
regular license.
regular license.
Once every 2 years, which is every
Right.
other year.
So if you want your master's, you turn it on the 5th year or every year?
Master has to be every year, the 5th year.
It
Wait,
has,
within-
it has
I know,
to
I
be
know,
every
within that.
year for a master, you have to have
Every
5
year
years
within that.
consecutively.
I get that, but turning it in only on your 5th year between January and March.
Every
Saying,
year.
hey,
And
this
then
is
it
my
would be
5th
a
year.
year after the 5th year. You still have, yeah, because it has to be tracked. So if
So
you're,
only the 5th year is when you turn it in to get your master's, right? Because if you
How
didn't
you
know,
tracking it for the
for
previous
us to
4
be able to
years?
track it, if that's something that you want to do, you have to submit it within that period of time for tracking purposes.
well, then we need to fix that, because what if someone didn't want to get them, didn't think they would want their master's the first 3 years and said, oh, or 4 years? Okay, I'll go ahead and turn it into January, March, and say, oh, no, that's your first year. You don't get your master's. Well, that's not fair. So we need to figure that out. You know, what if someone just wants to be a teacher and didn't think, now they, oh, I think I want to get my master's, I have to do it every year. So I'll go ahead and turn it between January and March on my 5th year. Now I want to get my master's, and they say, well, no, you didn't turn it. That's how we need to figure that out.
I think that's a different type of situation, and obviously we will run across those problems, but I don't, I'm
They should
pretty
give it to them
certain-
if they request it.
Absolutely, if they have a
Yeah.
record that they have for 4 years prior,
Mhm.
then yeah, I would
Good,
think that,
okay.
I would think that that could be granted. I mean,
Right.
it's done it for 5 years and they turn it in.
Okay, yeah, they would just maybe have to request it due to our
Correct.
I've
ancient.
never had a master instructor, and I've done my continuing education for 15 years.
I haven't either.
I don't know.
But there are some accreditation agencies out there that require at least one master instructor at your school.
But that's not how that's
It's
verified.
just, it's an instructor with 18 years experience through NACS and DOE.
Yeah.
Not to discredit anyone who hasn't and gets that continuing ed, but that's literally all it is to be able to say that you have your master educator license. It doesn't, no
It's not a
accreditation
law.
requires it, it's
Mhm.
not anything.
It's not even a law in our laws.
It doesn't, not to say it doesn't mean anything, but it doesn't, it's not required for anything.
I know, but it is a thing that some people is really important.
I'm not discrediting that, but it's not a requirement of anything.
Okay, okay, okay.
Okay, we'll go to public comment now. Ms. Sharon Franklin? Good morning.
Good morning. Do I go to the voice next?
Good morning, good morning, good morning.
Good morning.
So happy to be here this morning, and just on behalf of the Louisiana State Petitions and Barbers Association, we've been doing the continuing education now for some years, and we have given our documents that's required, our syllabus, along with the scheduling for our spring and our fall year, which will be on the next agenda, I'm told. But I just want to say that we are preparing and gearing up and ready to make sure that our educators.
Excuse me, Dr. Franklin. You put down you want to speak on 11 and 12. So 11.
Yeah, I'm on 11 right now,
Okay.
and I'm going
You know,
into
so-
that.
Okay.
I'm going to. Just speaking with some of the educators who have previously got their licenses and wanted masters. We have one particular person that we've talked to that's continuously been wanting and requesting that masters. They finally got their first recognition of their masters. And so what you're saying then, if you do your masters and it's not a requirement for any particular type of job or they put you in any particular category, what then is the use for the masters?
Nothing's different. We're not changing anything with the master's instructor status. That's the same as it always has been. It's just due between January and March to hopefully help our staff track you better.
So now those educators or instructors who've been coming continuously, what do they need to do to make sure that they get their staff now with their master educators?
Call and request, say, look, I've been doing it for 5 years and I don't have a master instructor license. I would like that to be on my license. Please put master instructor next to my name on the license.
And we've had.
Currently a master instructor, they will just turn it in January.
Okay, and they can this month between, we can notify them that they now can turn it in between January and March because this is something new to us. And we're learning as we're going, but I'm glad to know that because, you know, it means a lot to those who've been requesting it. Yes. Okay.
Yes.
Thank you.
Thank you. Okay, Ms. Elizabeth. Okay, then that's it for the comment cards. Any other comments? Okay, this line item. Okay, so, circling back, we're gonna clarify via letter sent out to licensees, schools, instructors, clarification on timeline for master renewal every year for the online submission between January and March.
Not only master renewal, any instructor renewal online,
The
any time of the year.
processes.
Yeah, any time of the year, and during any time of the year.
That already is in place. That's why we're clarifying.
Okay, we need to-
That's why we're
we need to-
clarifying,
okay,
yes.
We need to clarify that.
Okay. All right, I think that wraps up that. so we'll go on to the next line item, item 12, old business. For approval of a continuing education seminar. Or did you want to speak further?
I was just getting ready to say, is that me?
Yeah.
I had presented to the board members, and I believe it was attached as well to the agenda that Ms. Tasha emailed us. Over the last year, like Dr. Franklin just said, LSBC has been doing it this last several years. We had a lady who came who was trying to get into it, and upon listening to her and the questions that the board came up with, we were like, what is that criteria for continuing education? And we needed to have an answer for that. So this, which I have an extra copy, but it was also in your agenda packet, thanks to Ms. Tasha and Aaron. So I would like, moving forward, when someone has a seminar that they are proposing to the board, this is the process that I'm suggesting that they follow and adhere to. Not just for submission, but the requirements for a said seminar to be approved by the board for the 16 hours. Do y'all have any questions about that? I would like to go ahead and get a vote today and start this process as soon as possible.
And thank you for your time putting this together.
You're very welcome.
It was very well put together. So before we go on for a vote, I think Ms. Lsbc might have had, did you want to speak on this at all? Or Dr. Franklin?
Yes.
Okay.
And I promise I'm going to get those initials correct.
Okay. You've been saying sick for a couple of years.
I know. 2026 is the year.
Okay, I know it's Dr. Franklin, but I was also bringing up our new president for Louisiana State Teachers and Barbers Association, Dr. Sylvia Solomon. Basically, we've been learning and growing and massaging the program into our organization, and we have gotten, on our very last workshop, a very good, the requirements that were made were from suggestions from some of the instructors of things that they needed to be doing in their classrooms. So upon today, we submitted our syllabus along with our class schedule and things of that nature. However, I would love to see the criteria so that when we come on in February, we will have it together exactly like we proposed, and we'll have a proposal ready for you guys at that particular time. But this is our new president.
Welcome.
Hello,
And
everybody.
congratulations. I just passed around a couple of these copies as well, if y'all want to. And just to kind of clarify for those who don't have it in front of you, I literally have it typed out for them. It starts with application submission, and it goes all the way through to just everything that's needed. It's itemized, so. It also breaks it down by time, references, all kinds of things. It's pretty thorough. Yeah. There you go. I make a motion to approve the continuing education seminar.
I can second it.
All in favor? Any opposed? Okay, thank you. Okay, we'll move on to the next line item, new business. A line item is finger waves and cosmetology practical examination. So, finger waves and pin curls are, although they are still taught, they are still in the curriculum, they are still practiced at school. It is no longer on the NIC national test. we're hoping in the future, moving forward, to make some changes to our practical state board to make it more practical. We hear a lot of times that everything that they spend so much time learning, it's not some of the things they're using when they actually get into the salons. Finger waves, 10-minute finger waves, to get that down within 12 months takes some of the students longer than that, and they end up failing. Like I said, it's still in the curriculum, but we wanted to visit the idea because there are finger waves, brush curls, skip wedges on our wet work still. It was kind of redundant that they had to do a whole head of finger waves and get it done in 10 minutes. It's not a pass or fail, but it can contribute to failing. We want to look at removing that from the practical to make room for other things that we think are more practical for when these students graduate. So I just wanted to bring that up. Does my board have any comments on this?
Is there something you have in mind to replace that finger wave?
There's a lot, but.
I know, and I don't want y'all to think that the task force has been forgotten. I think we've mentioned it before. It just, we kind of had to pause things due to the technology, not to be redundant. We did communicate some changes that we were ready to present to the board. However, the way that they are scored and the rubrics that they use, none of that can be edited without causing the system to crash. So we had to kind of pause the progress that the task force was making until we are able to make those changes. So that technology upgrade is so important, so hopefully we will be able to do that sooner rather than later. But I didn't want y'all to think that the task force just fell off. And this is kind of in preparation for the changes that the task force is hoping to make. This is just making a little bit more room for those positive changes that the task force is hoping to make in the future.
So I'm requesting that we take this in consideration, bring it back up for a possible vote next board meeting. But I just wanted to let everyone know that that was something that we're working on. I think everyone needs to be knowledgeable about that. And it's just moving us forward in a good direction, I feel. But again, I'm always up to any ideas, thoughts, hearing from both sides. But I just feel it's time for us to step up and make it a bit more practical and more job ready when you get out. So, and there's a lot of areas, not just this one. Without getting into too much discussion about it, I think everyone will be pleased with the changes once we can actually get them together and present them to everyone.
Is this something that we need to notify schools for the next month? If they're not teaching finger waves?
Not until, all of that will have to be done, absolutely.
And honestly, finger waves aren't being removed from the curriculum. So like as a school, even if this passes, I'm not changing my curriculum.
Yeah.
I'm just not gonna have to
Dexterity.
focus as intensely as I am now
Yeah.
on getting the finger wave down to 10 minutes. I still plan to teach it, and
Yeah.
I'll be able to teach school at that point, but that's a whole different conversation.
There's a lot of practical hours that are spent during the day over and over and over and over doing this so that they can do it in 10 minutes.
Yeah, no,
And it could be, that time could be so better used.
Yeah,
So that's what my thought process is.
yeah.
So, if someone can make a motion and agree that we can move this to the next meeting, for a possible vote.
I make a motion to agree to move this to the next meeting for a possible vote of removing the finger wave on the practical exam.
I second putting this to vote at the next meeting.
All in favor? Any opposed? This is where I had asked to amend the agenda and just bring up the discussion for future legislature for a reform bill for hospitality. It's just introduction of our thoughts and what we're thinking of working on. the conversion of the alternative hair permit to licensure. This will create a pathway for those ladies and gentlemen who want to come back in and become instructors can do so. Right now with a permit, you can't re-enroll because you're not a licensed alternative hairstylist. You have to be a licensed cosmetologist, and you have to have a license to be able to re-enroll. So with that conversion, it will allow anyone who has taken the time and the hours and the money to be able to instruct. So that's something we want to work on. With that, our short courses, right now, our state minimum required hours is 500. There was a big issue last year, possibly the year before, Sherry, with the Department of Education. And some of our schools were in risk of losing their funding for their short programs. We need to increase the minimum required hours for our short courses to 600. In the event that the issue we had last year with the Department of Education won't be a problem for those that are already enrolled. This is not saying any tuition will be raised. This is simply, it has to be changed in our laws to move our minimum required hours from 500 to 600 for students to get federal funding. That would be encompassed within some of this legislature. And also the removal of the 12-month experience limitation for eligibility to become an instructor. So those are just a few of the things that I wanted to let everyone know that we're putting into this. So,
Yeah, can I say one thing just to clarify that? So the DOE decided to set a limitation on when you can get Pell Grants, when you can get the direct student loans. It also includes VA loans, disability loans, all that. That their minimum hours will be 600 hours, and then you can get the Pell Grants and get all your loans from the Department of Education. But it also has something in there saying your minimum state requirement has to be 600 hours. So if your minimum state requirement is 500 hours, well, even though your school, like our construction program, for instance, is 600 hours, but the state requirement is only 500. So the DOE is saying, no, we're not going to fund that for you. So it's the only reason we want to go up on those hours is to benefit everyone, is a benefit for the students, for sure, so they can get their, their student grants and Pell Grants and, VA even for all those. So that's the reason we're going up on that. And also, to back up on the licensure, alternative fair licensing, the big advantage of that too, let's say if you want to move to Texas and it's a permit, well, that doesn't transfer. But if it's a license, it will transfer state to state. So that's another advantage of that.
thank you. I had left that out. I forgot to say that. Thank you.
Can I come and say something?
What does this mean for people who would currently have a permit? How, for them, as far as getting licensed?
Would be converted into
If
license.
they would just automatically be converted into licenses? Okay.
Can I say something?
Absolutely.
Hello, everybody. My name is Lsbc Moffett, and I just want to clarify a lot of things about this alternative hairstyling. Let's get back to the hours. When this program was written almost 30, 40 years ago, which I put together and submitted to the board back in the 79, 80s timeframe. So this is not new. It was originally submitted as a license because I already knew. It just made sense. Why would I go to school to get a degree in cosmetology and spend the amount of money that you have to spend in the program and it be titled a permit? It always was intended to be a license. It was submitted as a license, not a permit. And it was submitted for $1,000 because I knew the Department of Ed, way back then, would not allow students to get a permit for anything under $500-600. I knew that 30 years ago. So that's why it was $1,000. That's not new. I still do not understand, the curriculum is the same. I do not understand how schools can input all of the information that a student needs to know to do a good job, a professional job in alternative hairstyling with $600 and still cover the information that's in the outline for the curriculum. Someone mentioned a couple of meetings back that they had issues with locks and dreadlocks not being in the curriculum. It's in the curriculum. You guys just don't know it's in there because you're not familiar with the curriculum. And no one, see, I sat back for years and watched this board appoint people on the board as the alternative hairstyling person, and it all failed. And you know why it failed? Because they didn't create it, and they don't understand it. It took me 40 years to understand it. But I understand it because I traveled, and I worked, and I studied with people who did the art and the science behind natural hair care. And I brought it back to Louisiana. And some of the same people, the states that have not approved or deregulated it, well, they have representatives in their state, and people that I know that they're not going to allow it because they understand it. And it put the state of Louisiana in a lot of predicaments by not really understanding.
Can you wrap up?
Oh yeah, alternative hairstyle. So I just wanted to let you guys know that. This is not new, you know? And I would really, really like for you all to get it right this time. Just get it right so that people can go and work and make a living. I would hate to see it deregulated.
Can you wrap up?
I know, but you open yourself up for the Institute of Justice to come in and try to deregulate it because you didn't understand and know what to do with it. Thank you.
Thank you, Ms. Lsbc. Okay, any other comments? So we will now go on to line item C, which used to be B, or is amended, the Executive Director's Report.
Good morning.
Good morning.
Hello, hello. All right, so the first thing in inspections that I have is the Inspector Productivity Report. You'll see that also in your packet. The number of violations that we had, and this is from November, just because we didn't have the totals yet for December. We had people working up until the day before the holiday, so. For November, we had 118 violations, 638 shops were inspected. Total inspections, including schools, 643. That makes an average of 8.5 inspections per day per instructor. For the 2025, I went and pulled your yearly numbers. So total inspections for the year, violations, 1,556. Number of shops inspected, 8,012. Total inspections, 8,016. Again, that includes schools. Average number per day, 6.9. And then I also have your listed current inspectors at the bottom of the page. And with that, for the inspector training, on the next page, you'll see, well, the next couple pages, this is a copy of the PowerPoint for their training that they're going through tomorrow to integrate the webcams and the iPads into the inspection process. So that is actually being done tomorrow. If you have any questions about the PowerPoint, just let me know. We do have a new inspector in the Alexandria area. It's Michael Grayson. You might be familiar with him. He's a former board member. So it's a nice familiar face to come in and pick up his items for inspection. For testing on the next section, I have your testing report on the next page. The total number of cosmetology practical tests, this is for December because we didn't have any tests the last week. I was able to get the numbers for December. We had 65 total practical tests taken. We had 37 retakes, and that includes per section. Renee, I know you were asking about that last time. For the written exam, they had 62 state exams. That's not the National Testing Center. Then we did have one retake on the state exam. For the practical retakes, the challenges that we're having is a wet compound ball is really significant. A lot of people are coming in with a wet mannequin before actually being able to do the comb out. And then when they do it, sometimes the back combing isn't smooth for the wet work. Brush wave and skip wave, and the 3 rollers on the top. Haircut, of course, is a uniform. One of the bigger things as well, ironically, I'll just discuss this, is they didn't complete the entire head of finger waves in time. That was something that they're failing. And then some of the saturation with the applications in the chemical head. For aesthetics, there were 22 people that took the practical exam. They did not have any retakes. For the state exam, they had 24. So that's our state gold book exam, and they do not have any retakes. Manicurist, they had 12 practical exams, 6 retakes. And then they also had 20 state exams with 1 retake. We did have 1 instructor practical last month. And just today, because there is instructor training, I think we have 7 people testing for instructor licenses, which is a great number. I was excited to see that on my desk. Monthly totals, so for scheduled, we had 234 that actually were scheduled and showed up. That's what that means. 50 did not show, and then 284 were actually, on the books to take the test. And then we had 9 open test dates. So we did open up 2 additional test dates last month for retakes. That's why you see a little bit higher in some of these other brackets. Just trying to catch up for the end of the year. Let's see. We do have a new tester. Her name is Miss Norma. So if you see her at the facility, please say hi. She's lovely. She is a licensed instructor, which leads me to the next little bit of a discussion. Moving forward, it's not really anything you guys have to vote for, but I did put a copy of the revised application for the testers, the examiners at State Board, and I did copy the law that we have regarding what it takes to be a tester or examiner at State Board. There was some confusion about that the first week that I was working in the office. Some people thought that you had to be a licensed instructor to be a tester, and you don't. So I just wanted to make sure everybody is aware of that. You just have to have 5 years of proven experience, just so everyone's aware. So if we do take applications for this position in the future, they do not have to be a currently licensed instructor, but of course I will do my due diligence to make sure that they were working it for the last 5 years. And if you look at the next page, under the testing section, we did start implementing 3 weeks ago now. Because I have lived on the other side for so long in schools, it's a student testing evaluation survey so that we can get feedback about the testing from the students in the process. So every student that comes through the door that's getting proctored an exam will then be able to fill this out at the end, and I've been getting those on my desk at the end of every test day and reviewing all the information and trying to quick solve any challenges, you know, with the exception of the color of the wall paint. Can't fix that just yet, okay? So, we also, in the testing facility, just something to note, there's been a little bit of a revision. Some things have moved around, so if you do come stop by, come see the layout. We added a smart TV back there, so tomorrow, for whenever we're doing trainings or staff meetings or anything like that, we're able to put up a PowerPoint. So that's been a lovely asset to have both in the testing area and the boardroom now, so we can actually see what's being presented. The next thing that I have on the agenda is the schools. So just something to note, and this also applies to shops, by the way, and they're pretty in for. It is the renewal period. January is here, so just something to note. And then number 5 is something slightly tailing off of what we already discussed with continuing education. I had received an email from a continuing education company called Rocket Cert and did a Zoom with them. I went online, got to actually log in with a mock credential, review all of their objectives and the course material. And you'll see that on the next page. It has the description of everything, and then it has the objectives on the next page behind it. This is a 16-hour continuing education option that's online, and I believe it's cheap. It's definitely cheaper than SEMA and Pivot Point. So we will be sending this out for approval if you guys approve this. If you have any questions, I'm ready for them. Anybody have any questions?
Are we gonna have a list of approved, like, when we send out the letter, approved Malay to the point of?
Yes.
Of approved online courses for, we'll have that on that letter as well? Okay.
Yes, I think that the ones that we had were the only 2 was SEMA and Pivot Point Lab. So this would add a 3rd option, and it is more cost effective for schools. SEMA is my lady. It's the name of their lab. It's okay. It's the name of their software, sorry. So their curriculum, yeah. But so this will add a 3rd option, and it is more cost effective. So for school owners that are paying for the continuing education, this gives them something that's cheaper, and it's actually different. So if you've been doing the same continuing education courses for the last 5 years since COVID, this is a different online option until we can get more in-person things like our own seminar going in the future. Does anybody have any opposition to offering this? Do we need to vote on this?
No, we'll have to put it on next month's agenda.
Okay.
So everybody can
Just
review
if y'all
it.
need to email me, I can send you the credentials to log in. I didn't put them on here. That way, if you want to go through yourself and just see what it's like. I only did the first unit, but I felt good about it. You know, I didn't have the 16 hours to put into it right now. But I also did attach what the certificate looks like. So this is what you would be getting with their renewal for their instructor license. It would look like that. And then the balance sheet is on the next page. So this is just giving you an overall. I do have an understanding that there is a profit and loss sheet as well, which I was not aware of until I was gone for the holiday, working late at night. So if you guys want me to start attaching that as well, again, I'm new to this, meeting. I can start attaching that in this every meeting as well. And then the cherry on top on the last page is that our legislative audit is beginning. So, yeah, it's actually happening, y'all. Okay. So we actually are meeting today, but this is just a copy of the letter that I received. And then we did kind of zhuzh up the state board letter just a little bit. We are actually 101 years old. Last year was our 102 years old, sorry. We missed our centennial. I know, I think we should still throw a party.
I must say, that was a very delightful executive director's report.
Oh.
I love the information. I like what you presented. Thank you.
Yes, thank you for that.
You're
It's
welcome.
been a busy December for you.
14 days.
14
Yes.
days.
14 days in office, I think.
Can you tell me where we are on getting updated technology?
I did miss one of my own things, by the way, because I didn't have to edit it, but whatever. I emailed the Office of Facility Management also about a week or so ago. They are gonna help, my understanding is that they help you with getting direction on what really needs to be fixed if you're trying to get like a quick items list of the things that need fixed in a facility, and they can come and audit the building so that we know, like, clearly,
Priorities.
yeah, what is the biggest priorities and all that. I mean, I know what I think is a priority, what is really a priority, you know? I mean, so I'm going off of trying to get in touch with them. I did email 2 people, so if they don't respond to me by end of business today, then I'm gonna email more people that are on their listing on their website tomorrow. And then I'm gonna start calling every day, because that's what I do. With the software, I think the last meeting I gave you guys the 6 different quotes with the cover sheet and what each thing had enclosed, and then also spoke with another local company. What we're trying to do now is, I don't know, because I wasn't here, right, what information was given to every single technology company for their bid. I don't know if they were all given the same screenshots of what they want things to look like and the same operation standards and the same, I'm assuming that they are, but I want to make sure for myself, especially with something that huge, that I'm able to understand, because again, I'm not like an IT person, but with William, he's our IT person, this is what it needs to do, this is gonna be the easiest to convert because it's Oracle, this is gonna, you know, and cost less. So we're trying to navigate right now with there were 6, with the 3 that we know work best with Oracle, because that decreases the price so significantly from having to transfer that information from the old server into the new, probably cloud, right? So he's been emailing them, but getting really delayed responses. Of course, it's been the holidays as well. So I'm hoping within the next month I'll get a little bit more between that and the facility, like, headway on those things. So, you know, yeah.
Thank you.
You're welcome.
Mr. Burns, you wanted to comment?
Yes, I do. To some extent, what I was going to say is negated by the fact that Aaron just referenced that there's a P&L accompanying the balance sheet. Because I know it's been a long time now, but as you've noticed, I don't forget. And I'm just going to say this. last session, there were materially false statements made about the financial condition of this agency. They weren't just false, they were demonstratively false. Easily demonstratively false. And so the reason that I have pushed having this in front of you, and I think it behooves this board to approve, if it's individually, so be it, approve the financial position, the financial statements that are put in front of you. Not just a discussion, a formal motion, a second, and an approval. That's done at just about any board or commission I've ever monitored, especially the Auctioneers Licensing Board. If you want Sandy Evans, this is contact information, I will give it to you. She decided it was easier to just include those financial statements with the agenda that was disseminated to the public. I don't know when there ever may be additional testimony by anybody affiliated with this board, directly or through employment. But I can promise you one thing, there better be a lot better knowledge of what the financial position of this agency is, what its income is, what its balance sheet is. Because if you thought that my attacks with regard to the last session were aggressive, to use a little bit of bad grammar, you ain't seen nothing yet. One of the ones who made that testimony is still with you. So it's just forewarned. I would strongly recommend, if you have in front of you an income statement or P&L, whichever you prefer to refer it, and a balance sheet, that you all formally approve those statements at this time, and to do so going forward. Now, I did make a public records request for it. Obviously, that's going to be very easy to fulfill because it's already readily available. The other part of the public records request, that's Reverend Phillips, so I'm not going to even go and address that because he's not here today, and I don't feel it appropriate for me to speak on something that he is near and dear to his heart and me possibly misquote him or not state it accurately. So thank you. That'll conclude my public comment with regard to the balance sheet and income statement, since we now know that one exists within your packets. Thank you.
Thank you, Mr. Burns.
You're welcome.
We have no more comments. We'll move on to our next line item on the agenda. The attorney's report. Our report really was mostly the declaratory order that was reported this morning. My understanding is that some of you have received in the mail a lawsuit that was referenced by Mr. Burns earlier, a petition for writ of mandamus. It is not on the agenda today. If necessary, I would request that it be included on the agenda for next board meeting with a note that it could be discussed in executive session. Any questions? Any comments? Okay, well then moving on, I just want to say thank you for all attending today. Some of you may not think so. We do work really hard to try to do a good job. We're trying to continuously improve and better serve our schools, our licensees, anyone interested in this occupation. So thank you for your patience, time, and support. This meeting is now adjourned.